evening, everyone, and thank you for joining us in this webinar today hosted by Royzz & Co. To introduce our topic today, I believe that the human race is a forgiving race for the most part, except on a few things, and especially one of those things is money. Very few people would be willing to forgive. It is said, to err is human, to forgive divine. But what about financial issues, and especially in the time of a pandemic? What do we do with the commercial difficulties that the world is facing? Whether it is regarding to infrastructure projects, whether it is in regarding to just being able to deliver your promises with regard to commercial transactions, people are facing a hell of a obstacle. And what do we do in such a case? And clients are coming back to the basic and the bedrock of every commercial transaction, which is the bank guarantee. So what do we do in a situation such as this when the client is asking for a compensation and we are stuck in this pandemic? And what is the court's view on that? That is the question really today. So bringing us to our topic today, which is bank guarantee, hedging the shockwaves of a pandemic. We invite our guest, Mr. Prashanto Chandra. It is a privilege to have you with us. He is the designated senior counsel of the Delhi High Court and is an alumnus of the University of Oxford. Mr. Sen practices in Supreme Court, Delhi High Court, and various tribunals in New Delhi. He has been on the panel of senior advocates representing the Competition Commission of India as well. He began his practice in 1998, assisting Dr. Abhishek Manu Singhvi. Subsequently, he joined the chambers of Mr. C.A. Sundaram and then went on to start his independent practice in 2006. He has been a part of key teams which procured landmark judgments such as the BALCO judgment. He was also part of the widely discussed case recently, which is the Competition Commission of India versus the Bharti Airtel Ltd, which discussed the telecom companies. He is presently appearing before the Constitution bench on the issue of the abrogation of Article 370. Mr. Sen has been involved in extensive pro bono work, particularly in the area of Right to Information Act. I also invite Ms. Mahua Roy Chowdhury, who is a principal partner at Royzz & Co. Mahua has had an extensive experience in commercial and contractual disputes. She has provided legal support and handled end-to-end implementation of mega infrastructure projects in the country. She has also been involved in various cross-border disputes and had the opportunity to advise on an alternative way of bank guarantee, a way forward for doing business in the future. Today in our discussion, we will cover, of course, the legality of bank guarantee, but we will also talk about an alternative way of doing business, an alternative way of securing businesses. So I request you all to stay tuned with us and please stay for the second half of the session as well. Thank you so much. Over to you, sir.
Thank you very much. Manjari, can you see me?
Yes, please.
Okay. Thank you very much, Manjari. Very good evening to you all. I'm extremely grateful to Royzz & Company for inviting me for this talk. And as Manjari rightly said, that these commercial things become very critical in a situation like pandemic. Especially in the area of bank guarantee, it's a bread and butter law for most of the commercial lawyers, because this is a law where mostly it is settled. There's a symmetry, there's a harmony. In fact, it's like a piece of great music that the jurisprudence is reasonably well settled in this area, except for a few jarring notes, which this pandemic has highlighted once again. And so therefore, I would like to point out that the jarring note here is, what is the scope and contours of the concept of special equities? As we all know, there are bank guarantee injunctions should not easily be given, subject to three exceptions. One is fraud, second is irretrievable injustice, and the third is the concept of special equities. Now, recently, in the context of the COVID-19, the Halliburton case in the Delhi High Court flagged a very important issue. This was a case where a contract could not be completed towards the end, since there had been this pandemic and a consequent lockdown. So what happened was that the parties approached the High Court under Section 9, saying that because of this lockdown, for reasons beyond our control, we cannot complete this contract. There should be an injunction to prevent the bank guarantee being invoked, because they apprehended that that is what would happen. And when they rushed to the court went into this issue. It referred to a judgment, the Standard Chartered judgment of 2019 in the Supreme Court, and said that the Supreme Court seems to have now come down to a view that there are three exceptions. One is fraud, second is irretrievable injustice, and third is special equities. Here, the significance of the Delhi High Court saying that there are 3 exceptions is as follows. Usually, special equities was being seen as linked with irretrievable injustice. And this was one of the few times where the court went into this and said, no, the Standard Chartered case seems to indicate that there is a third category which can stand by itself, special equities. So even if there is no irretrievable injustice, for example, if you take the Halliburton case, even if there is no irretrievable injustice, if there is special equities arising out of special circumstances, then the bank guarantee can be injuncted. Now, the problem of defining this contours is very critical because injunction of bank guarantees has a slightly different jurisprudence from the normal law of injunction, because bank guarantees are considered as the lifeblood of commerce. And in fact, it has been seen as the most common method of payment in mercantile world and has been described as the lifeblood of international commerce by none other than Lord Justice Kerr in the famous hard bottle case. They have been treated as equivalent to cash. It is for this reason that Donaldson, Lord Justice, in a commonly cited passage observed that irrevocable letter of credit and bank guarantees are lifeblood of commerce. Thrombosis will occur unless, if fraud is involved, the court intervene and thereby disturb the mercantile practice of treating rights thereunder as being equivalent to cash. So basically, bank guarantees cash, and you don't interfere with that. People are an entire commercial transaction, a mercantile transaction is based on this cash being given when you ask for it. So please do not intervene easily. And then, as thrombosis, as we all know, has been described in the Oxford Dictionary as a coagulation of clotting of the blood, and in certain cases may cause instant death. And therefore, this led to one of the Calcutta High Court judges remarking, I imagine that this is the kind of serious impact which is caused every time court interferes with or interdicts the working of a bank guarantee. A court, by interdicting or interfering with the working of the bank guarantee, is in effect intimating to the beneficiary that your cash is not cash, or that you are not entitled to your cash. This is akin to thrombosis in the business world. So therefore, as it is well established that bank guarantee injunctions should rarely be given. And in fact, even if it may appear harsh on the person who's the person who's given the guarantee, even in such cases, the court has held that one doesn't look at the underlying contract and what are the inequities which are because of those underlying contracts which are there. What one looks at is that the bank has got nothing to do with the inequity or equity of the relationship between the parties under an underlying contract. The bank is a facilitator of commerce. It has its own equitable principles it has to follow. It must honor the bank guarantee. And therefore, this case has been very well established. Just to repeat, I know that people here are well versed in this area, but just as a quick capsule of the principles. One is bank guarantee should not easily be interfered with. It can be interfered in the case of fraud. And here I'll make a slight aside. A very major contribution of Indians to bank guarantee law has been in this case of fraud. Before, bank guarantees were not injuncted. Sometime in 1941, an Indian party entered into a contract with a foreigner. He was supposed to supply bristles, and he actually ended up supplying some rubbish and heap which went there. As a result, this poor chap had to rush to the court and said that normally, of course, bank guarantee should not be interfered with, but this is a clear case of fraud. And for the first time, the court interfered on grounds of fraud. So we can be reasonably proud or lack of it, whichever way you may want to look at it, in making a very important contribution to the jurisprudence of bank guarantee law. The second is irretrievable injustice. Irretrievable injustice has been defined time and again as irretrievable injustice of the ITEC case. The ITEC case was a famous case where there were buyers and sellers involved between Iran and America. War was declared on Iran in between, and the relationships soured. And a situation arose where the party said that even if I were to win in America, I will not be able to execute this decree in Iran. And therefore, the concept there, in those cases, the court said we will interfere because it is a case of irretrievable injustice. That is, the person cannot recover his money at all. And therefore, in such cases, the court will interfere. The third case was special equities. Now, as far as special equities is concerned, let us look at it. This is the area which we need to concretize. What are the tests? What is involved? Equity has been defined as morality, justice, and good conscience. Now, these are very, very wide terms. And in a commercial context, these terms can play havoc because each person can have his own idea of morality, justice, and good conscience. It can really lead to not only one thrombosis, but multiple thrombosis all over, with various judges intervening in various ways. So something more is required to make it special equities. It should be special equities. It should not just be a case of equities. Now, as far as special equities is concerned, the concept for the first time was recognized by the Indian courts, by the Calcutta High Court, by Justice Mukherjee in the Texmaco case sometime in 1979. And he looked at what is called the Elian case of England, in which there was a bank guarantee which was given so that a ship owner could release his lien on the goods which were there. So when the bank guarantee was given, the ship owner released his lien, but then the ship owner tried to use that bank guarantee to enforce another lien with respect to some other aspect of the contract. In those circumstances, the English courts then at that time intervened and said, this is a special case. You can't expect people to go by way of litigation when this chap is on the face of it using it for a different purpose. And therefore they said special case. This word special case was then converted into special equities in the Texmaco case by Justice Mukherjee. And then Justice Mukherjee, when he went on to the Supreme Court, in the famous UP Cooperative Federation case, which is one of the fundamental landmark cases which has set the law for bank guarantee, raised this, again brought in this question of special equities. But then what he did was very clear in that test. He said special equities has to be something linked with irretrievable injustice, which means, once again, as I already pointed out, irretrievable injustice, that means you can never recover your money, or there's no possibility of recovering your money. Those would be cases of, so if a condition like that is arising, that is a special equity case. And in those conditions, yes, the court can intervene. And therefore, this line of cases came about of special equities. Now, in between, there was a slight deviation from this in the very famous case of the Hindustan construction case. The Hindustan construction case came to a case where it held, it was a conditional bank guarantee case. In that, there was a condition to be performed before the bank guarantee could be invoked. That condition was not performed on the face of it, and therefore the court intervened. And also it was a case of fraud, that because that condition had not been performed and they were trying to invoke the bank guarantee, it was a kind of fraud. But then at para 22, at the bottom end of the judgment, it is tucked away. And it says that there is a case where one of the parties had alleged that the invoker of the bank guarantee had actually abandoned the contract. But actually, when we look at the facts, we find that the person who was given the bank guarantee did not have the wherewithal to complete the contract, and he had made a wrong submission. And therefore, on that account, it says this is a case of special equities, and the the court can interfere. So this particular part which was tucked away was a deviation and a variant from the Supreme Court, because numerous judgments of the Supreme Court from time and again keep on linking special equities to irretrievable injustice. And here I will come to a very famous case, which is the BSES case, in which a very important issue was raised by Mr. Solicitor, one of our great lawyers, great senior advocates and great jurists. He raised the concept of breach of faith. And in the BSES case, he pointed out that a breach of faith can arise in many situations. For example, a failure by the beneficiary of the contract to provide an essential element underlying the contract on which the bank guarantee depends. A misuse by the beneficiary of the bank guarantee by failing to act in accordance with the purpose for which it was given. A total failure of consideration in the underlying contract. A threatened call by beneficiary for an unconscionable ulterior motive, or a lack of an honest belief or bona fide belief, such as poor performance. He in fact went on to say that sometimes a bank guarantee can be used by a party as a bargaining chip, as a deterrent. and said that what happens in a case where obviously there is no case in which this bank guarantee should be invoked, but he still goes ahead and invokes because, for example, some commercial negotiations have fallen out. What if he unilaterally changes the term of the contract, makes it impossible for me to perform, and then goes and invokes the bank guarantee? The Supreme Court, and by no less a justice than Justice Sri Krishna, again, one of the very fine commercial minds, said, I'm sorry, even in these cases, we cannot interfere in the bank guarantee, because ultimately what we have to see is, can he recover the money by way of a separate action? And if that can be done, there is no scope for interference. Justice Vikramjit Sen also in a very famous INSEAD case said that, you see, the bank cannot be concerned with the inequity or equity of two parties in a contract. It is a facilitator of commerce. It has to follow its own rules, and therefore you will not rely on the underlying contract for that reason. So that's how this law was very strongly put in. Then we have the Standard Chartered case of 2019. And the Standard Chartered case of 2019 very clearly points out that there are three separate categories: irretrievable fraud, irretrievable injustice, and special equities. And it seems to indicate that special equities it is treating as a separate concept. It refers to the earlier judgment, the Counsel judgment, which is of 1996, to talk about and describe special equities. And if we go to the Counsel judgment again, in there we will find that the Counsel judgment links it to irretrievable injustice. But the Standard Chartered case, for whatever reason, seems to make it a kind of a separate section. And maybe it had a premonition, if I may put it in a lighter vein, maybe the Supreme Court had a premonition that the COVID epidemic is going to strike, and therefore, there is something which needs to be done to make sure that justice is achieved. But in any case, that was there. And then in the Halliburton case, we had Justice the judge there, again, a very sharp commercial mind, noticing this fact that there is a third case of special equities. And it said that, yes, in a case like pandemic, when there is a complete lockdown, there has to be a case of special equities on its own merits, on the basis of which you can intervene in bank guarantee. Now, this raises one more issue. As far as Supreme Court is concerned, this was the law. High Court, in numerous instances, and I don't need to, what I pointed out as instances of bad faith, which Justice Mr. Soli Sorabji had pointed out in the case of BSES. Similar cases like that, various high courts have, however, intervened in bank guarantees. So if there are situations where the injustice of it all seems palpable, then courts have intervened. They have tried to do a balancing act by saying that you keep the bank guarantee alive till the issue is decided, so that you're not out of pocket. And at the same time, if your bank guarantee invocation is found to be correct, then you can always, the money is secure and you can take it. And therefore, it makes it easy for you to recover your money. There have been high court cases which talk about special equities and says, yes, there are only special equities is linked to irretrievable injustice. There are only two exceptions. So all I can say is that there's a polyphony of jurisprudence on this issue, at least amongst the high court, where the high courts are far more aggressive in their intervention and far more unabashed about it. There are few high court judgments which have tried to evolve a test for special equities. And one, for example, is the Sharma Calypso case by Justice Bhakru, where he said that special equities on its own can perhaps apply in a case of exceptional circumstance where there's extreme hardship in addition to a strong case on merits. So this could be one ground on which, standards on which special equity will have to be worked out. The reason why it is important for the Supreme Court today to rule on this and approach this head on is because otherwise it will lead to a situation where there'll be various kinds of instances left open. It will give a kind of carte blanche for the High Court to intervene. Some judgments have even said if it pricks the judicial conscience, now what pricks which judicial conscience in which way will lead to a lot of uncertainty. And it would internationally also compromise with the commercial reputation of India as a country. And as India has tackled COVID in so many other ways, in many ways there have been problems, and many ways it has tackled very effectively. Here also, I think it is important for the Supreme Court to deal head on with this concept of irretrievable injustice and come across with the test. So what could be the test of irretrievable injustice now? We come to that part. Now, there is the narrow view of irretrievable injustice, which I will not repeat again, which is it is linked. Special equities. Sorry, what concept of special equities, not irretrievable injustice. So there's a narrow concept of special equities linked to irretrievable injustice. It is a conservative view, but it is a safe view. It has stood the test of time. It has kept commercial, international commerce and domestic commerce well oiled. But yet now with a situation like this COVID, and also there have been situations where many times even government companies, government authorities and all have kind of used bank guarantees blatantly as a pressure tactic. In such situations, should not special equities be given more prominence and a test be brought out? Now, the most important point which has to be kept in mind is that a injunction of a bank guarantee is unlike a general injunction. General injunction, equitable considerations have to be balanced. But in this case, as they said, special equities means it has to be something far, far above than normal equity, normal good conscience, normal this thing, which is why the BSES case had rejected the bad faith arguments of Mr. Solicitor. So when we look at special equities and the danger of subjectivity which it poses, one perhaps test which I can suggest, and keeping in view the fact that this COVID which is there has made it far more clear as to situations arising where such a test may apply. One, it should consist, special equities should consist of three factors cumulatively. One is that it is a wholly unanticipated event, and an event which is well known to everyone. You don't need to prove anything. You don't need to. It's not like a force majeure clause, because law is very clear that even if there's force majeure and it has been wrongly, and even in such situations that the bank guarantee is being invoked, it has to be honored because ultimately the person can recover his amount. So we are not talking about force majeure clause generally. But yes, at a wholly unanticipated event which is not dependent on a particular contract, which is affecting worldwide like a global pandemic, it's events of such nature. And earlier also situations like this have arisen. For example, there was the pandemic in 1898, the bubonic plague. Of course, at that time, commerce was not so well developed, so perhaps this issue was really not gone into. But today, this issue is there. So a wholly unanticipated event. Then extreme financial hardship to the point of extinction, that if the company is not able to, if the bank guarantee is invoked, it will lead to extreme hardship. And I'm saying this in the context of government regulations, government directives which have come that please keep paying the employees for any kind of, even if work is not going on, please continue the payment. People have to continue work in essential commodities, etc. So therefore, once again, a extreme financial hardship, which in these circumstances must be looked into. And then extremely good prima facie case of merits. It should be there that there should be a case of bad faith, a person trying to use the bank guarantee as in a negative way. So I think tentatively suggesting, and people, as I can see from the seminar, I had a quick glance at the people who are participating here, who have fine financial minds, would be able to, perhaps can add, chip, add, qualify, fine tune this thing, but this is what the test which I can give. And therefore, I would now like to just conclude by saying that the COVID crisis is being seen as a pivotal moment, which is challenging the old world order. It has been a time of great tragedy, which is bringing out searing inequality and the need for our country to universalize its healthcare. But there have been positive spin-offs as well. It has been for many a time of rediscovery, spiritual development, and in many ways getting clarity on the fundamentals in life. And in the commercial legal world, it would not be an exaggeration to say that the COVID crisis has opened up the possibility of getting clarity on special equities. Thank you very much.
Thank you very much, sir, for that. I really liked your conclusion, and that is so true. And another thing that you said, that commercially we have evolved from the last plague that happened. We have evolved substantially, and that is so true. So, sir, just to bring a practical expression of what you've said in this. So, when it comes to, say, construction projects or infrastructure projects, or even supply chains such as medicine equipment, etc. Now, these are necessities. The definition of necessities has also changed over time. So, what do you think should be the court's view? How does the court balance this out in this sort of a situation?
I think here the court's view should be that this is a case of special equities.
Okay.
Especially the construction industries. I mean, if you look at the migrant labor, which is having to move around all over, it's linked with the construction industry which are working. So if the construction industry is expected to pay the salaries of many of these people who have to stay back, which it should, if that is the financial burden which is there, and construction is not taking place, and then you have, say, a body, a government body, or anyone else moving to invoke a bank guarantee. I think here the equity has to be. It is a case of special equity, clear, and it would be a case where it would be, a situation where the bank guarantee would be injuncted. The Halliburton case is an example of a much lesser degree. So,
right.
I mean, using the Halliburton as a principle, it would be open for them to go ahead and say that, no, in a time like this, equity, what is equity and good conscience? I mean, this is of a higher nature. You need to be helping everyone out. And therefore, in such a situation, going for the bank guarantee on a specious ground that the construction is not as per the time limits prescribed in the contract would not be proper.
I think that is a great view of what I think many businesses will face at this time. And
Yes.
I think that is very helpful for people who are listening today. So I think moving on to the next part of our webinar today and looking at a cross-border element and looking at a wider element of what could be an option or an alternative to bank guarantee. Bank guarantee has always been recognized as a bedrock, as something that is essential to every commercial transaction. So I'm just going to move over to Mahua and just invite her to just bring in the next part of the topic for us. Thank you.
Thank you. Welcome, everybody. It really encourages us that on Saturdays we conduct this. It has become now a ritual, and we look forward to all do something constructively, and it energizes the team for us, to involve ourselves in academics. And this is a time we are taking opportunity to revisit our academics. So talking about bank guarantee, there is an alternative way which I had experienced, and I believe that will also pave way, an alternative way of doing business, which is a lesser known alternative as of now. But we had some experiences as a firm, and I would like to share this. That extending this conversation where we see that a bank guarantee is more or less absolute. Yeah, there are certain grounds, but those are exceptions, and court will not be lenient on that in injuncting a bank invocation of bank guarantee. I would like to today highlight a lesser known optional way of providing a comfort and security for the purpose of a performance guarantee, and share my experience in that. It is an alternative way of doing business and currently being used primarily by tech and digital companies. We are seeing that the economy, the major M&A transactions and investments is happening, where the conventional companies are now wearing a new jacket, and they are wearing a new jacket of being a digital company. So tech and digital company will play a major role going forward. Thus, in this scenario, which the alternative way I'm talking about, instead of a bank guaranteeing the performance, an insurance company steps in as a guarantor. So as you all know, the domain of insurance services is much more evolved in other countries than in India. And there the insurance companies provides much more wider product range as opposed to India. They thus have a plethora of precedents also in common law. However, we have seen that liability insurance, and another extension of that, which I am going to talk about today, is professional liability insurance, which is in its nascent stage and still evolving in India. But it has been highly tested in other countries, and they have adopted it as an alternative way of doing business as against a bank guarantee. And I believe that as a practitioner, that insurance domain has a much more opportunity and potential to develop in India. It is just the tip of the bird than what has been adopted in our counterpart Western countries. So we have come across many agreements in which this is now a prerequisite, especially for Indian IT companies, which are mainly providing services offshore. And it is now have become a way of doing business, especially in countries like USA. In UK also, they have a similar kind of a thing of a professional liability insurance. I will call it as PLI. In UK, they call it as performance bond. Even for construction companies, This bond can be availed and provided by insurance companies as well as a bank. Now, I like to highlight that how does this liability insurance, which can be availed even in the form of a professional liability insurance, for example, by an IT solution or service provider companies, can be an alternative mode of doing business. So a PLI can provide a wider comfort for failure of performance of a party's contractual obligations. A PLI, according to me, has a broader sense which covers your omissions and errors, including negligence, against any claim of the service recipient, as well as any claim of a third party. Thus, you can say it is triggered in the event of any dispute and claim by including the dispute and claim raised by the recipient of the service and even by a third party. So the claim money as damages and even the cost of the litigation is borne by the insurance company, as long as the allegations and the nature of the proceeding is not of a criminal nature. The grounds are similar as that of a bank guarantee. That is allegation of fraud, as Prashanto said. We have a little bit of misreputation. So fraud will not be covered, and any such mixed allegation, including fraud, can actually lead to a negotiation with the insurance company. So if you are the recipient of the service and you are triggering and raising a claim and you are initiating the dispute, then do not raise the allegation of fraud, because that will take you away from getting the damage, and it will be a difficult way to settle out of court as well. So the broader grounds wherein this insurance claim can be invoked is, first, unintentionally breaching of a binding contract with a client, including unsatisfactory performance or not receiving the desired performance of the product assured to be delivered. We have witnessed such claims much prevalent in IT solution providing companies, and we have done such cases where the litigation arose in US, where Indian company was the service provider and the recipient was in US, and it was a software development kind of a project. 5 years down the project, when the project was supposed to be almost completed, and there was a dispute which was raised. Sometimes these disputes are disguised also to get a big claim from the insurance company also. But at least it safeguards you from doing business, whether in India or whether doing offshore, where the liabilities are very high and even the litigation costs are very high. The second one is breaching of duty of care or negligence. So it covers bad advice even given to a client or making even professional mistakes in the course of the work. But mind you that I'm not talking about just professionals of lawyer, doctors, engineers, architects. No, this has been extended to even service provider companies like construction, IT. And if our insurance companies are evolved, we will see a wider net of this coverage as well by the insurance company in India as well. Third one is it can include claim of infringing of intellectual properties of third parties as well. So if there is any claim of third party, like in IT companies, we see lot of such claims of third parties. It can cover your claim from the third parties also. Fourth, breaching of confidence, that if sharing of sensitive or confidential information of a client or any third party without prior consent of the latter, maybe there has been some leakage from your employees, even that can cover also. Fifth, in the event of any defamation, if there have been damages or false claims made against an organization or person. Sixth, civil liability. As I said, criminal nature of any kind of proceedings is not covered in this. So even if a claim is made against the IT firm, which is not included in the contract and it has not been excluded specifically by the policy's conditions, then it is covered. Thus, the terms of the policy has to be scrutinized properly and negotiated with the insurance companies, because these kind of agreements are extensive agreements, and most of the time we believe that these are one-sided agreement and we have to just sign on the dotted line. But as this domain is still an evolving domain and the stakes are high, it is very much negotiable in contract with the companies. So it can work well even in the construction industry, you know, where I believe that there are multi-stake service providers involved in any project. There are various suppliers, there are architects, there are municipal architects, there are licensed agencies for seeking NOCs and all. So it can work both upstream and downstream and can bind all the service providers in a project. So thus it can bind even the architects, the varied suppliers for ensuring a timely delivery by all stakeholders involved in a project, and can provide a wider comfort to the person who is contracting the project, because you are binding your downstream supplier also before extending the comfort ahead upstream. This insurance can be taken in a bundle, including liability of the directors, and can be negotiated accordingly with the insurance companies as well. The only pitfall which I see and I have experienced, that Indian insurance companies need to promote and encourage companies to buy this service, which is actually tested when a dispute arises. You know, in a typical case of our day to day, when a motor accident claim happen, and once you go and claim it from the insurance company, you run from pillars to post. You are made to submit documents, you get into an argument, negotiation. I think that is the more to do with the Indian way of doing business, which is not an easy way. But in one of our case, we had a very contrasting experience. We were simultaneously dealing with an Indian insurance company as well as an US insurance company, because there were two carriers which were giving overlapping insurance to that client of ours and the company. We had a smooth selling where the US insurance companies was involved. That as soon as you notify them, they just started giving you the support on an ad hoc basis, that while our investigation is pending, we will start giving you the support. Subject to our investigation, if there is any adverse, then we will withdraw it. But they supported it. Whereas the Indian company, we had a lot of discussions, a lot of arguments, and lot of negotiations. So I would say that the Indian insurance company has to actually evolve, show more maturity in this, and encourage the companies to come forward and take this as a product, as a service, and as a normal course of doing business. Now, comparing it with a bank guarantee, why we are talking of insurance than a bank guarantee. You may be seeing that I am promoting insurance company. No, it is not. I believe insurance companies have, even healthcare and all, has lot of potential in India. So whereas a bank guarantee is triggered due to non-performance or untimely delivery, or in the event of insolvency to perform the obligation, a liability insurance also covers allegations of negligence to perform. It is much more wider. It is much more broader than your financial capacity to perform. Thus, the coverage is much wider, and the premium of an insurance will not be necessarily equivalent to the value of a project, as insurance companies are in the business of risk. So whereas a bank guarantee mostly taken, a percentage, a substantial percentage, or sometimes even equivalent to the value of a project, which you have to upfront, secure with the bank. And insurance as against is on a premium. And that insurance actually protects you not just for one contract. That insurance protects you for multiple ongoing contract of the company at that time during the operation and duration of that insurance in that annual financial year. So it has a much more wider, thus letting another, and also I believe that when you are doing business, letting another agency carrying the risk while performing a contract, I believe it is a much more assured way of doing business. It's much more peaceful way of doing business, that the risk is taken by another and there is a backup of mine which is there. So this is what I wanted to suggest as an alternative conventional way of doing business. Thank you, Prashanto, for coming on board for this interesting topic. Yeah, I am unmuting yourself. Yeah. You have to unmute yourself.
Sorry. Thank you very much,
Yeah.
Mahua, for inviting. And
Yeah.
I'm hoping that, I shouldn't be saying this so openly and brazenly that even in the insurance sector, there'd be disputes, hopefully, for the litigating lawyers to be involved in.
Of course, I always say this as a legal profession. Even if recession is there, even if your company is going down, you need us. Even if you're going up, you need us. So
Yes,
we have chosen our profession well.
Right,
Yeah.
that's right.
Yeah, Manjari, you can go on to the question answers.
Yeah, I think there's one question that I'd like to raise, which says that, Mr. Sen, to you, what if a particular party is already not doing well financially, and the lockdown pandemic situation has only spurred on the deterioration, so they're already not in a good place? Should that be considered as an important factor when looking at bank guarantee?
Yes, for that period, because it's a peculiar situation where you are having to pay employees also, even while the lockdown is there. You can't get out of it. It is something which is known to everyone. So yes, definitely, for the period of the lockdown, you get a kind of relief, and thereafter you have to maybe when before court, depending on the facts and circumstances, what can be worked out is that beyond the lockdown period, also some hiatus of time for that person to recover, because it may be a situation where immediately you cannot recover from a lockdown.
Right.
So I think that, yes, definitely.
Right. So I think that pretty much you all have given us a very comprehensive view of this topic. I think it's gone beyond just bank guarantee and beyond the pandemic. I think I've really enjoyed this discussion because I think I've learned more than just what happens during COVID. I think we are hearing about COVID in every webinar. There is something about COVID. But what I like about what both of you brought out is something that goes beyond COVID, that goes beyond just what is the practical aspect of it, but what should be done and what should be the legislation as a whole and what should be the way of practice of business. And I just want to thank you both for that. So thank you both, and thank you to our listeners for being so patient and listening to us and giving us your time on a Saturday. We hope to see you soon again in another webinar. Thank you so much. And another person says,
yes, thank you very much.
Someone is saying bank guarantee and insurance covered very well. That is so true. Thank you so much for both of you.
Thank you so much. Thank you very much.
Thank you. Thank you. Thanks.